Yeah, good evening, everyone. Hello, I am Manya Khanna, an Operations and Corporate Relation Associate from Karuna Mediation, and welcome you all on behalf of Karuna Mediation and Arbitration Institute. So, Karuna Mediation and Arbitration Institute vision is to spread awareness about mediation for resolving disputes with compassion and empathy. Further, Karuna Mediation imparts training to the newcomers to make them learn the techniques of mediation and use them in resolving disputes of the conflicting parties. So we welcome to you all, and we welcome Sir also, Dr. Aman Sir. And we welcome Shulini University of Legal Science as our knowledge partner, which is established in 2009, which is established in Solan, Himachal Pradesh. Is recognized by UGC and NAC. It ranked in the top 200 globally as the impact rankings in 2022. Shulini University provide us undergraduate and postgraduate programs in various diverse fields like pharmacy, management, engineering, law, etc. So in progress towards our vision, we will be organizing some related webinars to spread awareness about mediation for students and professionals who will be the future building blocks for this sector. And today's webinar will be on professional skills of mediator. To impart and share knowledge about today's topic, our guest speaker, Dr. Aman Hingorani, sir, will throw light to understand what professional skills are required to have a successful mediation session. So, Dr. Aman Hingorani, sir, practices as an advocate and mediator in the Supreme Court of India and Delhi High Court, and also in various other tribunals and courts. Sir has been appointed as an arbitrator in the Delhi High Court and has trained various for the international, has been a trainer for various international advocacy and mediation skills program, and trained various students and professional lawyers also. Sir has been authored various books related to diverse legal topics, which is presented in India and on international basis also. Sir has been associated with various organizations for mediation programs. And sir, it's a pleasure to have you, sir. Good evening very much. So before proceeding, I request to all the participants to please put their mics on mute, and if possible, do open your cameras, because it's an interactive session then only possible. And all the questions do you have, and whatever the question will be coming in mid of the session, please put down the questions either with yourself or in the chat box so that we can take up in the last of the session. And please don't make confusion in the bit of the session, please. And thanks you all. So now I request sir to please share his viewpoints on today's topic.
Thank you, Manya, and I'm grateful to Karuna Mediation for giving this platform to discuss on mediation. Now, since I can say it's a small group, and as Manya said, that we can try to make it interactive as opposed to a long lecture. I would request you to unmute yourself and say and interact, even if you are not in a position to switch on the video. Because I mean, it would depend whether you are in a position where you want us to see you on video. Now, coming to the topic, which is professional skills of mediators, or in what a mediator should possess. Before I get into that, it's important to understand the conceptual difference or the background of what mediation is all about. So would anybody like to share what they think is mediation? How would you define mediation? What do you understand by the word mediation? Anyone? Just unmute yourself and share your views.
Yes, anyone can try, please.
So what, according to you, is the meaning of mediation? Would anybody like to say something?
Yes, sir, I can give a bit information on this. So mediation is something which is part of the act, which is Arbitration and Conciliation Act, which is a kind of an out-of-court settlement wherein we used to reduce the burden of the court, which already a lot of burden is there on the courts. So we just try to take less of the time of the court and try to settle the disputes out of the court.
Okay, so one way of looking at it is it's alternative to the formal legal system. That's why we call it ADR.
Right, sir.
Though we do have court annexed mediation, which makes it integral to the legal system also. Another comment is, I can see from the chat, is that it helps resolve the cases amicably. But then so does negotiation. There are many other ways by which cases can be resolved amicably, not necessarily through mediation. More importantly, what is the role of a mediator? What is a mediator supposed to do? Because if we talk about the professional skills of a mediator, what is it that the mediator, what is the purpose of having a mediator? What's the role of the mediator? What's the function of the mediator? Anyone?
So it helps the disputing parties to reach a settlement.
Okay. Now, how does the mediator do that?
The mediator facilitates the process. He helps the parties come up with creative solutions to their dispute.
So the solutions have to come from the parties. The mediator controls the process. So let's take a step back, one step back from that. The difference between the adversarial and the non-adversarial. I mean, you have litigation, arbitration in the adversarial mode. You have mediation, negotiation, and so on and so forth in the non-adversarial mode. The distinction which we have to keep in mind when we talk about mediation is that how are you handling conflict or a dispute between parties. Now, suppose A and B have an issue about something, they have a dispute. They can go to the respective lawyers and the lawyer will say, well, let's adjudicate or let's go for arbitration. This is the adversarial mode. The lawyer would take away the socio-economic context, the emotional component. The lawyer would put everything in terms of rights, liabilities, try to fit the facts of the case as per the statute, present the case before the judge, who's the third neutral party, or the arbitrator. And it's the judge or the arbitrator who decides, there's a decision, who decides the dispute and hands it over to the parties. In the process, the parties, say A and B, they are completely disempowered. They have no control over their own dispute. They're not the ones taking the decision. A and B did not like each other, that's why they were fighting with each other. By going to a court or to the arbitration, that prejudice is maintained. The communication remains blocked. Each one will say it's the other side's fault. There's a blame game going on. So in the adversarial system, what you have is you have a third neutral third party who's deciding the conflict, which means one side wins, one side loses. If we compare and contrast this with mediation, the common example, the textbook example is that of an orange. And is anybody aware of that particular example? Title to a particular orange? It's in every textbook for that matter.
Yes, so the one where two brothers are fighting or two sisters are fighting, one wants the peel, another wants to make the juice out of that orange.
Okay, so putting that in context of what we're talking, suppose there's a dispute over an orange. In litigation or in arbitration, the judge or the arbitrator will decide who has title to that orange. If A has title, A gets it. If B has title, B gets it. So one person will win, one person will lose. But in mediation, if the mediator is able to get to the parties and understand why they want that orange, as you say, one person wants the peel to say, make pickle, and the other person wants the inside of the orange to make juice. Then the mediator will say, forget who has title to the orange. The mediator can give a suggestion, why doesn't one party keep the peel, the other party keeps the fruit? So it's a win-win situation. You're transforming conflict. You're not deciding conflict. So the approach in mediation is to get the parties to shift from the stance they've taken to the underlying interest of what is really biting them. Why are they litigating? Or why are they fighting? The role of a mediator is to facilitate that, shifting from the stand to the underlying interest. For a mediator to do that, the mediator has to understand what is it in the mind of the parties. The mediator needs to get into the mind of the parties to break the conflict cycle. What is the conflict cycle, anyone? A conflict cycle. Again, these are textbook definitions. No one? Okay. Now let us assume, I mean, all of us have our ambitions. We like things, we want to get things. We have our desires, our requirements, our needs, our objectives. And if we get what we want, we are happy about it. But if we don't get what we want, then there's a sense of frustration. Why am I not getting this thing? So what do? We sit down and we do a self-analysis. Perhaps if I behave in this particular way, I conduct myself in a particular way, or I say things in a particular way, I'll get what I want. If that analysis is correct, you'll get what you want. But if that analysis is wrong, then the modified behavior would invite an even more adverse reaction from the other side. That adverse reaction will again trigger off more modification in the behavior. So then a conflict cycle starts. The job of a mediator, or the role of a mediator, is to be able to get into the mind of both A and B to understand where the self-analysis of A and B went wrong. Where was A wrong in the self-analysis? Where was B wrong in B self-analysis? To be able to decondition A and B to say, well, there's another way of looking at things. Make them step back from the problem so that they're able to, in a rational state of mind, break away, realize where they went wrong in self-analysis, and then they themselves suggest what is the way forward. For a mediator to be able to do that, obviously mediation has to be voluntary. If the mediators to get in the mind of parties, the parties need to lower down the defenses. Why would a stranger share the intimate, vulnerable thoughts with another person? Only with their own consent. So mediation has to be voluntary. Mediation has to be party-centered. Because you're empowering the parties, they are the ones who have to decondition. They are the ones who have to decide or resolve their own conflict. It's under the cloak of confidentiality that a person will lower down the defense. A person is vulnerable. You want that person to share the intimate thoughts, the thinking process. No one will share their thinking process with another person unless they are assured that whatever they're going to say will remain confidential. So mediation has to be confidential. And nobody is going to give away their rights till they're satisfied that they've got the underlying interest satisfied. And so mediation has to be without prejudice talks. It's a non-binding process. So if you think of a definition of mediation, it's a process. It's a party-centered, voluntary, confidential, without prejudice, non-binding process. And for a party to be able to lower down the defenses, build a rapport with the mediator has to be neutral. Mediator has to be impartial. Mediator has to be credible. It's only then that person will share information. Now, in a given case, it's not important what the mediator thinks is the right way forward. It is what the parties feel this is the way they want their interest satisfied. So the mediator has to gather information about the parties, their situations, their priorities, their interest underlying their positions, how they want to see their interest satisfied, not how the mediator thinks the interest can be satisfied. So everything we do it from the mouth of the parties. If this is the role of a mediator, if this is what mediation is all about, then what are the performance skills? What are the professional skills? Obviously, one is communication. It's like a pyramid. On the base of all professional skills is communication skills. And I'm sure you would have, those of you who have done law, studied communication theories, it's not a unidimensional process. A person says something, the other person, that message is sent through a medium, is downloaded by the other side as per their experience, their conditioning. And then there's a feedback. That's a communication cycle. Now, there are many techniques of communication, which I can get into if we have time, but I'm sure most of you would be familiar with them. Their listening skills. People can listen to almost 4 times the number of words they speak in a minute. So that's why you gather far more information by listening. And then there are different kind of listening skills. Active listening, passive listening. Are you familiar with these words? What is active listening and passive listening? Anyone?
Yes, sir. Little bit of that. Active listening is what we are directly hearing from the parties, and the passive listening is, I think, all about that is what we are gaining from their expressions, body skills mainly, and indirectly what they want to say to us by.
No, that is non-verbal communication about which will come.
There,
Yes.
actually, active listening is something. It's a skill, and active listening exactly means that. So, for example, we listen to 10 words of the person on the other line or on the other hand. We are able to retain most of the words or most of the things that they have told. That is what active listening is. To retain the most.
Well, I think one has to retain everything if you want to gather information. The distinction basically is the degree of intervention by the listener, that is the mediator. If a party is speaking, you let a person speak for, if you say 10 words or 5 minutes, 5 sentences, 6 sentences. Now, to show that you're paying attention and you're understanding, you as a mediator can do many things. One is you can show acknowledgement. If you're merely nodding your head, using non-judgmental, non-evaluative words like I see, I understand. You're not agreeing with what the person says, but you're acknowledging what the person is saying. Then it is passive listening, where you're simply giving an acknowledgement that you're paying attention. If you do something more than that, if you are summarizing what that person has said, and you're reflecting back to that person the same thing in a concise manner, accurately and completely, in a non-judgmental, non-evaluative manner, then that is active listening. So say somebody is describing an accident, and say that the driver was driving very fast. So if a person is saying, well, I was driving and this driver overtook me from my left-hand side. He was driving very fast and rashly. And then I saw him go, he would try to overtake the car in front of him, and they collided. So I saw the accident. Now, in passive listening, you'll say, I see, I understand. In active listening, you'll try to summarize this. Oh, I see. So you saw the rash driving, fast driving by the driver, which resulted in the accident. So you're reflecting back what the person has said. The minute you do that, there'll be an immediate rapport being built with the person, because the person will feel, the person who's speaking will feel that this person is listening to me, he's understood what I've said. These are techniques of building rapport, building a kind of a bond between the two people, the speaker and the listener. So this is in a way where you reflect back what a person is saying. Active listening can also be related to the feelings. What the example I've given is content reflection, where you're reflecting the content of what that person has said. You could also reflect just emotion. Suppose there's a property dispute, the builders messed up the construction, The owner is an old man. He's lost all his life savings. He's come to the mediator. He's telling the mediator that I'm completely ruined. All my money is gone. Construction is faulty. And he's saying this in a choked voice, bent over. So a feeling reflection would be, I can see you extremely disturbed. I can see you're very traumatized or you're very upset. So what you're reflecting is not the content, but the emotion by which a person is saying something. There'll be immediate release. That person who's speaking feels a sense of release and discharge, that here's finally a person who's understood what I'm going through. So here you're reflecting the feeling. It's important to identify the correct feeling and the intensity of that feeling. You can't say, I can see you're a bit disturbed. You must know the degree or the depth of that feeling before you reflect back that feeling. So there are skills, and we can go, but keeping a view of the time, we can expand upon this later on if we need to, but there are different skills of listening. There are questioning skills, leading questions, non-leading questions. What are leading, non-leading questions?
So leading questions are one which are suggestive in nature.
Okay, so in a cross-examination, we would put leading questions to the witness of the other side. That is a statement of fact and close it so that the other person gives yes or no answer. So you went there, didn't you? Non-leading questions are questions where you give a platform to the person to say whatever they want to say. So questions with who, what, where, how, did you, please describe. These normally are non-leading questions. So you would always start with a non-leading question because you want that person to speak and say whatever is important in the mind, in their mind. So as a mediator, you would want the party to speak. So you start with non-leading questions. Who, what, when, why, how. Let the person say whatever they want to say. If the person is rambling or you want more details, then you will focus your non-leading questions. Where were you yesterday at 5 p.m.? Focus on time, focus on a date. And if you want a confirmation of a fact, which that person is not giving, then you can ask a leading question. This happened, didn't it? Yes or no. So it's like a funnel. You start with non-leading questions, narrow down the questions to leading questions. And then, of course, there's non-verbal communication by which you can see what from the body language, from the expressions, eye contact, waving of hands, posture. You can get clues about what the person is all about. As a mediator, what's most important is when the non-verbal behavior contradicts the verbal or the spoken word. A person may be coming across speaking very confidently, but he or she is twitching their fingers all the time. You know they're nervous. You can test the sincerity of a person by seeing a contradiction between verbal and non-verbal communication. And then the communication inhibitors. It's the job of a mediator to identify the communication inhibitor and overcome it. So a person may say, let me not tell this to the mediator, he'll think less of me. That's a case threat or ego threat. Because if I tell this to the person mediator, he may think my case is weak, I won't tell it. That's a case threat. If I tell this to the mediator, he'll think poorly of me. That's an ego threat. Or I don't even know this is relevant to tell. That's a perceived irrelevancy. I don't want to recount a painful incident. So that's a communication inhibitor of a painful history. Many times we slant or abstract. We hear only what we want to hear. So we abstract whatever information we want, which that's convenient to us, or we give it a slant to suit what our narrative. Whatever may be the inhibitors, it's a job of a mediator to identify them. And then there are many techniques by which a mediator can overcome those inhibitors, because it's only when that inhibitor is overcome that you will get free flow of information. Without information, you cannot mediate. So the whole purpose of communication is to gather information. So you have to have excellent communication skills. You have to have negotiation skills. In a mediation, a lawyer can have many roles. A lawyer can negotiate on behalf of the client. The lawyer can be the mediator. And I'm sure you would have studied negotiation skills, choosing the right time to negotiate, researching what the other side, making a shopping list of what you can live and live without. So the way you go to the market and say, I must buy this today. These are things I can live without. If I get a good price, I'll take this. Similarly, before getting into negotiate mediation, as a lawyer, you must know these are the things my client must get. If I get these things, these objectives are satisfied, at this price, I'll accept it. These things I can live without. These are things I can concede, I can give away. So you need to make a shopping list when you get into negotiation. Always get into negotiation with a smiling face, positive, consensual approach, giving credit to everybody, starting with the easier issue. The mistake we do often is we start with the most difficult issue and say, well, if this is settled, everything else will be settled. It's better to start with the easier issue. If there are 5 issues, settle one, settle second, settle the third, then keep saying, see, there's so much movement. You have settled 3 or 5 issues, only 2 are left. So you build a momentum to a settlement. So it's a lot of psychology involved where the other person feels that if I break the negotiation now, I'll lose even the settlement on the 3 things we settled upon. Everybody has their own negotiation styles. I'm sure you would have read about them. Accommodating, competing, collaborative, so on and so forth. The bargaining techniques you should be familiar with, the negotiation strategies you should be familiar with. Again, we can expand upon these if you're not really familiar with them. But what's important that in a mediation is party-centered. So the lawyer must take a back seat. Let the parties do the talking. The lawyer should chip in only if there's a power imbalance or there's some clarity on legal points or for drafting the settlement agreement. Otherwise, the lawyer should let the parties control the conversation, not the lawyers. As far as the mediator is concerned, the mediator must have many facilitative skills. The mediator must be able to reassure the parties about his neutrality, his credibility. The mediator must be able to address the issue of confidentiality, which is at many levels. Whatever is said in mediation is confidential. Whatever, you can have a private session mediation. So whatever is said in mediation in a confidential manner in a private session cannot be disclosed to the other side. The settlement agreement is confidential unless you need to get it executed or enforced. The mediator cannot be a lawyer or an arbitrator for any of the parties. Mediator cannot be called as a witness before the court. In a court annexed mediation, the court can't ask the mediator what transpired in mediation. So there are many levels of confidentiality which needs to be explained to the parties. Then you would the mediator has to respect the principle of self-determination. The mediator can give suggestions, but the mediator cannot impose a decision. And even while giving suggestions, it's important that suggestions should be given only at the last stage. It's important for the parties to feel that it is their solution, so they take ownership of the solution. Then they won't try to wriggle out of it. So it should not come across as though it's a mediator's idea. The mediator has to maneuver the conversation that it comes across as the party's idea. It's only if you're reaching a stage of deadlock, then a mediator should give suggestions. The mediator must recognize communication barriers and overcome them, as I pointed out. The mediator should be able to take out the sting of a hostile comment by one party and present that thing as a positive need to the other side. Now, As you all know, a mediator will, in the opening statement, tell the party that one person is speaking, the other one should not interrupt. So say A is saying something which is hostile, which is insulting to B in the presence of B, and you restrain B from speaking. If A keeps on insulting B, the environment will get vitiated. So you as a mediator have to step in. You would do what I talked about, reflecting, doing active listening, reflecting back the statement. But in addition to that, you will also use the technique of neutral reframing. You'll neutrally reframe what that person has said so that the focus is on the underlying need, not the offensive word. So say, take a matrimonial dispute. The wife is going on and on saying that he's selfish, talking about the husband who's sitting in front of her. He's selfish, he's self-obsessed, he doesn't care about my feelings, he doesn't never listens to me, he doesn't take my opinion, he has no respect for my views, he is full of himself, and so on and so forth. You have restrained the husband from interrupting her. So you would be reflecting back. I can see that you're concerned about the need to be heard. So I see with one part, the emotion, you're concerned, you're upset. And then the substance matter, what is the underlying need? The need to be heard. So then the focus of the husband will be on this underlying need, not words like obsessive, selfish, and so on and so forth. Take another example, say in a dispute between two neighbors on the boundary, the placement of the boundary of a fence on a boundary. Suppose one neighbor is saying to you as a mediator, in the presence of the other mediator, in the presence of the other neighbor, my stupid neighbor has built his fence on my side of the boundary line and now is refusing to move back even though I've told him where that boundary line is. You can again take the same formula, acknowledgement, emotion, positive need, or the substance of the dispute. I see your concern about the placement of the fence. So what you're doing is you're trying to take away the sting from that hostile comment so that the environment does not get vitiated. It's conducive for negotiations. Then yet another facilitative skill of a mediator is to generate momentum towards agreement. So like in negotiation, the mediator will start with the easier issue, setting the agenda, start with the easier issues, keep praising the parties for the progress they've made, keep reminding them about how many issues have been resolved, keep resurrecting the outstanding issue, only this teeny weeny bit is left. So you're building a momentum that parties are shifting from this positions they've taken to the underlying interests. It's a job of a mediator to recognize when the parties are coming to a deadlock and try to prevent it. Or once there is a deadlock, then to break the deadlock. And again, there are many strategies, role reversal, making A step in the shoes of B and vice versa, deferring the mediation, getting expert intervention, shifting gears between joint session, private session. There are many techniques about how to handle impasse or deadlock, as we call it. Then it's a job of a mediator to be able to draft a settlement agreement. If it's a private mediation, as per the existing law, it can be specifically enforced. If it's a conciliation agreement, it's a decree of a court. So the settlement agreement must contain a statement of the parties' future relationship, not the past history. Describe the responsibility of each party in implementing it. Who will do what, when, where, how much, for how long. You have to use words which are specific. You can't have ambiguous words such as reasonable. A will pay B rupees 1 lakh as soon as possible. It means nothing. A will pay B by demand draft in his favor within a period of 2 weeks from today. Everything must be closed. A timeline must be given. So you can't use words like reasonable, as soon as possible, frequent, cooperative, practicable. The language has to be clear, concise, complete, concrete, realistic, workable, executable. The language has to be balanced and should gain that everybody's getting something out of it. That's why it's a win-win situation. The language should be positive, no blame assessment. And the language should not be judgment, it should be non-judgmental. So you can't say A will pay penalty of so-and-so or damages. Or it will be in full and final settlement of all claims, A will pay this amount of money. So there's no blame assessment. Use plain, simple English, no legal jargon, no slangs. It is the parties' agreement, they have to understand it. So drafting a settlement agreement is itself a professional skill. And then the mediator should be able to adapt to technology to be able to do online mediation. With COVID and so on and so forth, there's been a push towards virtual mediation. And then in addition to all this, there are different rules. In a physical setting, you can ask a person to step out in a private session. You can do that in a separate room in the virtual medium, but suppose there are no separate rooms, or even if there's a separate room and you need to enter the separate room of the other party, you can't go unannounced. You have to ensure whoever's in the room are only the necessary party. You can't have strangers in the room, in a virtual room. So there are many other issues which have cropped up with online mediation, and a mediator must be familiar with this. So now, these are some of the skills, but how do you do mediation? So the minute a matter comes to you as a mediator, you'll do a pre-mediation dispute analysis. And there are many models by which you can do it. A very simple model is by telling, even before you get into mediation, trying to see what are the underlying interests of the parties. So A will be told, take a sheet of paper, list your underlying interests which are most important to you. So your most important interest, then your second most important interest, and so on and so forth. Then think your B and guess what is the most important interest for B. Put these two envelopes in a sealed envelope and leave it in my chamber or in my office. B will do the same exercise. Rank the interest in the sequence of importance to B, and then guess what's the most important interest for A, or what would be the most important interest for A. So B would leave the two lists in the sealed envelope. Even before getting to mediation, you can open up the envelopes. You have 4 lists before you. You will see how the parties have ranked the interest, what's most important to them, where they're willing to trade off, where they're willing to give concessions. So you can do that pre-mediation dispute analysis. It will help you in getting a framework for mediation to know where concessions should be given, what a settlement could look like, who are the necessary parties who should be there in mediation. It will help you to also decide whether you're competent and qualified to take that mediation. Is this in a field of which you're familiar with, even if you're controlling the process? So you'll be doing a pre-mediation dispute analysis. Then you go on for giving your opening statement, which is important, which sets the tone of mediation, which has to be conversational, by which you introduce yourself, get the parties to introduce themselves, and show all the parties are there. Give them a roadmap that you can have private sessions, talk about confidentiality, talk about the role of mediator, talk about the ground rules of mediation if required. You can ask the parties if they've been in mediation before. If they have, you can give a short opening statement. If they haven't, then you go to give a longer opening statement. Handle administrative matters. It's a deliberation, it's a process, it can't finish off in one day. How much time do you have on that particular day? How you'll be scheduling the mediation, and so on and so forth. The demeanor has to be social, it's conversational, offer a cup of tea, make people comfortable, use neutral body language, use neutral, plain, simple words, use words of mutuality that apply to all parties. So either party can request for a private session. I would request both parties, that one party speaking, the other should not interrupt. So words that mutually apply to both sides. That's the way you build your neutrality, by having use words of mutual application, having equal eye contact with both sides, equal deference to both sides, use a calm, moderate, business-like tone, attentive posture. All this goes in building the neutrality, impartiality, and the credibility of the mediator. There's no point saying I'm neutral. You have to come across as being neutral. You take the parties through different stages, both joint and private. After the opening statement, you would get into the problem understanding stage, the needs and interest understanding stage, then redefining the problem, identifying the issues, identifying the options, evaluating the options. But all this has to be done to the mouth of the parties. After the opening statement, parties share the perspectives to indicate what the problem is. Parties will identify the needs and interests. Parties will redefine the problem. The parties will identify the issues. The parties will put the options on the table. The parties will be evaluating the options, not the mediator. We don't do that in this country, but that's the way a mediation is supposed to be done. It's the mediator simply guiding the parties, maneuvering the conversations. Everything should come out from the mouth of the parties. It will then be the party's solution, not that of the mediator. So if you see it from this point of view, go back to the definition of mediation. Mediation is a party-centered, voluntary, non-binding, confidential, structured process, which is controlled by a neutral and credible third party who uses special communication, negotiation, facilitative, social, and technological skills to assist a binding negotiated settlement by the parties themselves. So that's the textbook definition of mediation, and each of this element would require professional skills, which I've talked about. So I'm keeping a track on time. It's 4:43. We can keep the floor open for question and answers. Of course, there are other issues I could talk about, in which I did want to speak about, was also the issue that all this has to be done within the parameters of the ethical standards laid down by this, which are actually put in the rules, Rule 27 of the Civil Procedure Mediation Rules of 2003, which was examined by the Supreme Court in Salem Bar's case, 2005, Volume 6, SCC 344. And those ethical standards have been, which are there, they're also a part of the Delhi High Court Mediation Conciliation Rules of 2004. So you have Rule 27 there also. So these standards are laid down. If we have time, we can discuss the standards. But first are the questions on what we've been talking about so far. Excuse me. Any questions? Please feel free to ask them now.
Yes, any questions, anybody? Anyone can ask. Yes, anyone?
No?
Yeah, I think so. Sir has explained very much well. They don't have any questions.
Okay, then I'll move on to the issue of ethics, because that is something which is somehow not given much attention. Once we talk about mediation. So there are certain rules which have been, we have the mediation bill, which is still pending, that might bring out new ethical standards. But the standards which are already in place is that the mediator should not carry on any activity or conduct which could be considered unbecoming for mediators. So that's a general kind of a rule. The mediator must uphold the integrity and fairness process. So let me take a situation. Suppose you're a mediator in a matrimonial dispute. And there's a settlement. 2 years after the settlement, the husband approaches you and says, I was so impressed by you and your sound legal knowledge that I want you to represent me in a unconnected commercial matter of my company. Should you as a mediator agree? As far as the rules are concerned, Conciliation Act simply says that unless the parties agree, a mediator will not be a lawyer, arbitrator, and so on and so forth for the parties. So it is for a mediator cannot be a lawyer for a party with respect to the same subject matter. And that also mediator can if the parties agree. This is a situation where the subject matter is different. You are a mediator in a matrimonial dispute, but you've been requested to become a lawyer for one of the parties in a commercial dispute. Should you still agree to become a mediator, or it's fine, there's no ethical issue involved? Anyone?
Yes, sir, we may if we are not biased.
I beg your pardon?
Sir, we may become their lawyers if we are not biased, if we still reach to that amicable solution, a
So
legally valid solution.
can the wife turn on and say that this was a deal done by the mediator and the husband in a private session, by which that the husband said, persuaded to accept less alimony or waive of alimony, which the wife had done, and I will get you after a cooling off period of say 2 years, I'll give you a big case where you'll have a lot of professional fee. Can the wife say that this particular settlement agreement is a product of fraud because there was a deal between the husband and the mediator 2 years ago?
It can be said by the wife. We cannot say like this.
So then, but suppose the husband comes after 10 years, does it make a difference? Is it the same situation?
Yeah.
Sir, unless and until,
Yes.
sorry, sir. Sir,
Yep.
unless and until it has affected the mediating process or the final decision, unless and until it has caused any hindrance to that, it is legally valid and ethically just, I believe.
You know, with the way we've been discussing that the job for mediator is actually to get into the mind of the parties, lower down the defenses. So parties are very vulnerable to the mediator.
Yes.
And during the mediation process, if a mediator has that kind of control or sway over the parties and is able to persuade, indirectly, of course, maneuver the conversation in such a way by doing your reality check in a private session, your partner, etc. And a wife has agreed to something, waiving of her rights. She says, okay, fine, on your suggestion, I'll keep the custody, I'll waive off alimony. That's more important to me. Custody is more important than alimony. I'll earn money later on. Later on, she feels that this was deliberately done by the mediator to reduce the financial liability of the husband. So it's not an issue of whether a person has taken, the wife may have taken a rational decision at that point of time. But tomorrow, can she say that my decision, that I was led into taking this decision by the mediator, who was having a private deal with the husband, who would benefit him later on? So there are no easy answers.
I don't think.
Yes.
I don't think she can claim such. I mean, if there's a case and then she has fought and she's won something, and now she can't come back saying that, okay, after 2 years or 3 years or whatever, saying that it was done for some in haste or whatever. But I don't think she can do a claim this now. She's lost the battle there.
So according to you, she can't really come back and say that.
Yeah, ideally no.
Okay. So
because that was prevailing. That was the best thing what you did then. That is the best thing she wanted then. And she can come back after 3 years or whatever. I mean, that's sympathy is different, and that's a different issue. But then she can claim that my husband has collaborated with the mediator, and then they've done this kind of fraud. That cannot be told now.
So as you see, there is a conflict. I mean, there is a divergence of opinion even within this 8-9 people I have out here as to whether there is an ethical issue or not. So there are no easy answers, but one of the ethical standards is upholding the integrity of the process and the fairness of the process. Now, when it comes to the fairness of the process, it's not the same as fairness of the settlement agreement. It's not the job of a mediator to get into the. So for so long, the parties have taken a rational, informed decision. Even if it is unfair, the mediator has to go by it. If there's a power imbalance, or a person is not rational, or a person is taking a decision without fully appreciating the facts and the law, yes, a mediator can step in to remove the power imbalance. But if a person is taking an informed decision, it is not for the mediator to talk about the fairness of the settlement, because that would go against the principle of self-determination. Now, that seems pretty obvious, but take a situation again. Suppose there's a matrimonial dispute between husband and wife. They have 2 children, say the boy is 3-year-old, the girl is 2-year-old. And they're arriving at a particular settlement by which they're saying, the father will keep the boy, the girl, the mother will keep the girl. So they're splitting the children from each other. You as a mediator feel that is not fair to the children. Parents are taking divorce, not the children. So on the face of it, it may be unfair to the children. On the face of it, it may not be in the welfare of the children. And particularly if the court next mediation, you have a settlement agreement, or if it's a conciliation agreement, the settlement agreement is a decree of a court. Would you, let us assume this is a private conciliation settlement agreement, would you authenticate the settlement agreement? Because you're not concerned with the fairness of the settlement agreement according to the rules. There has to be fairness to the process, equal difference to both sides, private session one side to be followed with the private session with the other side, equal opportunity of speaking to both sides. The process has to be fair. But here the settlement agreement is within the parameters of the law. It's not outside the law. In fact, the parties can say, well, you take a walk, we don't really need to come to you anymore. We can do a direct MOU ourselves. Thank you for your services so far. We'll terminate the conciliation and we'll have our own agreement if you don't authenticate it. So should you as a conciliator authenticate a settlement agreement when you're convinced that it is unfair to the children? Anyone? No? Again, ticklish issues. And these are actual issues which we face when we do mediation, for which there are no easy answers. Yet another ethical standard that the parties involved in mediation should be fully informed, have adequate understanding of the procedural aspects of the mediation. Now, suppose there is mediation before you, and a party A is represented by a lawyer who actually is giving the wrong law to his own client, because of which party A is taking a stand. There is a power imbalance to that extent, or there's actually also a blockade. There could be a deadlock on that point. It's not a job of a mediator to tell the parties the law. That's the role of the lawyer of representing party to tell the party the law. But that is blocking the, when we talk about the requirement of parties being fairly informed, party A is not being fairly informed because of wrong legal advice being given by his own lawyer. What can a mediator do, or should the mediator simply ignore it? It's not his job.
Sir,
He can intervene. Sorry, someone saying something.
Okay, but what would you do?
You redirect the questions. You take you give hints to your party if it's mature enough to understand, or questions which can be asked by the mediator to make the whole picture look different.
Also, if you tell a party, obviously this can't be done in a joint session. You won't tell in a joint session that you're giving wrong advice to your own client. Now, in a private session, if you tell the party your lawyer is giving wrong advice, the lawyer will block the mediation process for once and all.
No. So you're not telling your party that your lawyer is giving wrong information.
And
You're only trying to ask the party different questions.
but which would be shot down by the lawyer when the party goes to lawyer, because no party would sign a document till his or her lawyers cleared it. So perhaps in this situation, yes, you can intervene, you're right, but perhaps in this case, it is better to have a private session with the lawyers, the lawyer of party A, and in an indirect way suggest he looks up certain citation, etc. And of course, follow it for the sake of formality with the lawyer or lawyer B, so that that neutrality is maintained. And then just hope that the lawyer of party A does get familiar with the right law and then accordingly changes the advice. So again, in mediation, you need to actually adapt the process depending on what is come. You see, anything that the lawyers are one category of people who can easily block a settlement agreement. And one of the principles of mediation is that every person who can block a settlement, who can facilitate a settlement, should be made part of the process. So a lawyer has to be dealt with accordingly when we're talking about coming in the way of a party not being fairly informed. Then there are other ethical requirements that the mediator must be satisfied that he or she is qualified to undertake the mediation in a professional manner, must disclose any interest or relationship likely to affect impartiality, or which might seek an appearance of partiality or bias, avoid while communicating with the parties any impropriety or appearance of impropriety, be faithful to the trust and confidentiality imposed in the office of mediator, refrain from promises or guarantee of result, maintain reasonable expectations of parties as to confidentiality, and so on and so forth. So there's a whole list. But on confidentiality, while the statute is quite clear about confidentiality, an exception has been carved out by the Supreme Court when it comes to custody and matters, guardianship matters. That is Perry Consagra's case of 2019 SEC Online Supreme Court 211, where the Supreme Court has taken the view that the welfare of children are paramount, and the court in a guardianship matter acts as parents' patriarch. And so every information from every source should be made available to the court while deciding a custody matter. And so it's perfectly okay for a mediator or a counselor, child counselor, to submit a report as to the prevailing circumstances in the home, the relationship of the child with the parents, and so on and so forth. And so confidentiality will not be attracted to that extent. Now, in my view, this is a completely wrong judgment, because it is only under the cloak of confidentiality that a party will share the vulnerabilities will disclose whatever's happening, what the reality is. The purpose, the mediation cannot be used as a discovery process of the court to discharge its own function of deciding cases. If we remove confidentiality in these kind of cases, my experience in these cases has been that the parties refuse to bring children to court or refuse to bring them to the mediator or for child counselor, because they don't want the mediator or a child counselor to give a subjective report to a judge to be used against that party within that adversarial system at the time of litigation. And the minute a court says, compels a party to bring a child to the mediator, you're bringing an element of coercion, and that defeats mediation. Mediation is dependent on the goodwill of parties. No one can force a person to mediate. Nobody can force a person to lower down the defenses and share the vulnerabilities, or to share things they don't want to share. So this judgment, according to me, takes away from party autonomy, takes away from the whole issue of the voluntary nature of mediation. It damages the mediation, success of mediation in guardianship cases, because the fallout of this particular kind of a judgment is that we'll terminate mediation, but we will not bring the child if there's no confidentiality, because what guarantee do we have that a subjective fact will reach its way to the judge who's going to be deciding the case on merits? So of course, there are many other ways of looking at it, but the bottom line is that the courts have no business treating mediation as a process of discovery of facts or to gather expert opinion about children. That's not the purpose of mediation. So that's one exception which you should be familiar with, which is there in the existing case law. Though the statute is very clear, the draft or the mediation bill, of course, has other exceptions of confidentiality, which has been critiqued. So, but that's another debate. So since it's past 5, I'll stop here. If anybody has any last minute questions or clarifications, you can do that. And I'll hand it back to Manya now.
Yeah, thank you so much, sir, for sharing your viewpoints. It was amazing to listen to you. Anyone, any other questions you have?
So just wanted to check if there are any books which we can refer for techniques on mediation. Some good books.
Well, actually, mediation, you just Google, you'll find plenty of material online about techniques of mediation. But my suggestion would be and that's the way we do training, is that you have to actually do mediations, even in simulation exercises, for you to be able to appreciate and internalize the different techniques. Because we go on the assumption that people absorb about 30% of what they hear. They absorb about 60% of what they see people do. But if they do things themselves, they absorb about 90%. So there are many institutions, many courses which are offering training programs in mediation. See which ones offer learning by doing sessions with individualized, detailed feedback on the performance of the participants. So those kind of training programs, because there are all kinds of training programs, some are theoretical, some are very old dated teaching methods, but there are other programs where you have more recent teaching methods and more current, more contemporary content, things about restorative justice, things about smart contracts, artificial intelligence. So programs which are updated in terms of content and the teaching method. If you can enroll for one of those, that will be far more beneficial rather than just reading a book on it. Because on paper, it seems pretty obvious. It seems to be the logical thing. But it's only when you're on the hot seat and actually performing then you realize the kind of challenges that come your way.
Thank you, sir.
Yeah, thank you so much, sir, for sharing your viewpoints. Now, I request everyone to please fill out the feedback form, which has been shared already in the chat box. And I request everyone to please open their cameras for the last pic so we can have a memory one of them. So yeah, thank you so much, sir. And thank you everyone for participating with us. And thank you, sir, for sharing your viewpoints on this amazing topic. I hope once again we will discuss on this more elaborately.
Thank you, and thank you everybody for being here.
Yeah, thank you so
sir.
much.
Thank
Thank
you.
you. Any question
Thank
of
you.
yours will be taken afterwards. No worries. You can share us on our LinkedIn page or our mail ID.